The house stood exactly as I remembered it, 2 stories of weathered brick, wraparound porch, oak trees older than anyone in the neighborhood. My uncle Harold Garcia had lived here for 37 years, and now it belonged to me. At least, that was what his will said. Comment below if you have ever dealt with HOA troubles of your own. You are not alone. What I found when I pulled into the driveway that October morning made me question everything I thought I knew about property rights in America. A white van was parked near the front steps, and a man in a gray uniform was standing at the door with a power drill in one hand and a shiny new deadbolt in the other. He had already removed the old lock, the one my uncle had installed 20 years ago, the one I had a key for. I stepped out of my car and walked toward him, trying to keep my voice calm. I asked him what he was doing. He barely glanced at me before answering that he was changing the locks per instruction from the Willowbrook Estates Homeowners Association. I told him this was my property, that I had inherited it from my uncle, who passed away 6 weeks ago. He shrugged and pulled a folded piece of paper from his back pocket. It had the HOA logo at the top, a stylized W inside a shield, and a block of dense text beneath it. He said the association had initiated foreclosure proceedings due to outstanding fees. According to this document, I had no legal right to enter the premises until the matter was resolved. He went back to installing the new lock if I was not there. I asked to see the document more closely. He handed it over without protest. The first thing I noticed was the absence of a notary seal, standard for any legitimate lien enforcement in Texas. The second was the date the foreclosure action had supposedly been filed just 2 weeks ago, but there was no evidence of the required 90-day notice period to the property owner. The third was the signature line at the bottom, signed by someone named Diane Hargrove with the title, President, Willowbrook Estates, HOA. No witness, no attorney certification, just a single signature authorizing the seizure of a property worth over $1 million. I handed the paper back and said nothing. Some things are better left unspoken until you have all the pieces. I asked the locksmith if that was even what he was, how much the association claimed my uncle owed. He did not know the exact figure, but he had heard it was substantial, somewhere in the range of $47,000. The number made no sense. 3 months before he died, Uncle Harold had shown me his financial records during one of my visits. He had walked me through everything: his retirement accounts, his property taxes, his HOA payments. He had pointed specifically to a line item showing his annual dues paid in full through the end of the year. I never owe anyone a dime, he had said with the quiet pride of a man who had spent 30 years as an accountant. That is how I sleep at night. $47,000 in unpaid fees would have kept him awake for years. It would have been the first thing he mentioned when I called. It would have been impossible for him to ignore. I called the HOA office from my car. A woman with a professionally pleasant voice answered and confirmed that, yes, the Garcia property was currently in foreclosure status due to unpaid special assessments dating back 3 years. I asked what kind of special assessments totaled $47,000. She said she could not discuss the details over the phone and suggested I come to the office the following morning to meet with the association president. Her name was Diane Hargrove, and she would be available at 9 o'clock. The woman wished me a pleasant day and hung up before I could ask another question. 3 years of unpaid assessments. But the document I had just examined referenced an action filed 2 weeks ago. If the debt was 3 years old, why had they waited until after my uncle died to act on it? Why had they moved so quickly once he was gone? That night, I slept in my car in the driveway. I could have driven to a hotel, found somewhere more comfortable to wait out the night, but something kept me there. The same instinct that had guided me through hundreds of property disputes over the years. The instinct that told me when the numbers on a page did not match the reality in front of me. The foreclosure document was missing basic legal requirements. The timeline did not add up. And the man who had raised me after my parents died, the man who balanced his checkbook to the penny every single month, had supposedly accumulated a debt larger than most people's annual salary without ever mentioning it. Someone was lying. Tomorrow morning, I was going to start finding out who. The Willowbrook Estates HOA office occupied a corner suite in a small professional building just outside the community gates. I arrived at 8:45, 15 minutes early, and found the waiting area designed to impress: leather chairs, a glass coffee table, framed photographs of the neighborhood on every wall, The receptionist offered me water and asked me to have a seat. Diane Hargrove would be with me shortly. I declined the water and remained standing, studying the photographs. They showed tree-lined streets, manicured lawns, and happy families at community events. None of them showed the 2.8 acres behind my uncle's house, the largest private lot in the entire development. I wondered if that was intentional. At exactly 9 o'clock, a door opened and a woman emerged. She was perhaps 58 years old, dressed in a cream-colored blazer and pearl earrings. Her silver hair styled with the kind of precision that suggested weekly salon appointments. She extended her hand and introduced herself as Diane Hargrove, president of the Willowbrook Estates Homeowners Association. Her handshake was firm, her smile practiced. She welcomed me to the community and expressed her condolences for my uncle's passing. Harold had been a valued member of the neighborhood for many years, she said. His absence would be deeply felt. The words were polished and empty, delivered with the same tone someone might use to describe the weather. She gestured toward her office and invited me to step inside so we could discuss the situation in private. Her office told a different story from the neutral waiting area. The chair she offered me was noticeably lower than hers, positioned so I had to look up slightly to meet her eyes. Behind her, a wall of certificates and plaques competed for attention, volunteer awards, Chamber of Commerce recognitions, photographs with local politicians. The arrangement was designed to establish hierarchy before a single word was spoken. I had seen this setup before in depositions and negotiations. I sat down anyway and waited for her to begin. What caught my attention was not the display of authority, but the absence on her desk, no computer, no files visible, just a single manila folder placed precisely in the center. She had prepared for this meeting with specific documents and nothing else. Diane opened the folder and spread several papers across the desk. She explained that my uncle had accumulated significant unpaid assessments over the past 3 years, special fees for road maintenance, security upgrades, and community beautification projects. The total outstanding balance was $47,216. The association had sent multiple notices to his address, she said, but received no response. After exhausting all other options, the board voted to initiate foreclosure proceedings in accordance with the community bylaws. She spoke slowly, deliberately, as if explaining something complicated to a child. I asked to see the notices they had sent. Her fingers paused on the folder for half a second, so brief I might have imagined it before she slid a stack of papers across the desk. I counted 4 letters, all dated within the past 18 months, all addressed to Harold Garcia at the property address. None of them had tracking numbers. None of them showed proof of delivery. I asked if these were all the notices the association had sent over 3 years, just 4 letters for a $47,000 debt. She said the board had also attempted phone contact and in-person visits, but those efforts were not documented. I asked her what specific assessments made up the $47,000 total. She produced an itemized statement: road resurfacing $12,000, security system installation $15,000, landscaping and beautification $8,000, administrative fees $7,000, penalty charges $5,216. I studied the numbers without commenting. The road in front of my uncle's property had not been resurfaced. I had driven on it yesterday, and the same cracks and patches I remembered from 5 years ago were still there. The community security system consisted of cameras at the main gate, installed long before any of these assessments were supposedly levied. And $8,000 for landscaping seemed excessive for a community that hired 2 part-time workers to mow the common areas. I kept these observations to myself. I asked Diane why the association had waited until after my uncle died to pursue foreclosure. She leaned back in her chair, and her voice shifted, still controlled, but with a new edge beneath the professional warmth. She said the board had hoped Harold would eventually respond to their outreach efforts. They had given him every opportunity to resolve the matter amicably. Unfortunately, his passing had created an urgent situation. The property was now in probate, and the association needed to protect its financial interests before the estate was settled. I asked if the foreclosure action was legally required to go through probate court. Her jaw tightened. She suggested that I consult with an attorney if I had questions about the legal process. This was an internal HOA matter, and the board had followed all proper procedures. I told her I wanted copies of everything: the notices, the assessment records, the meeting minutes where the board voted to initiate foreclosure, the bylaws, provisions authorizing the action. This time, the hesitation was unmistakable. Her hand moved toward the folder, then stopped. She straightened the papers already on her desk, an unnecessary gesture that bought her 3 seconds of thinking time. Then she said that some of those documents were confidential board records not available to non-members. I reminded her that I was the legal heir to a property within the community, which made me a de facto member under most standard HOA bylaws. The professional mask slipped entirely. Her voice went flat, her eyes hard. She said she would need to consult with the board's legal counsel before releasing any additional documentation. It might take a few days. I stood and thanked her for her time. I told her I would return on Friday to collect whatever documents she was able to provide. As I walked toward the door, she called after me. Her tone had changed again, softer now, almost sympathetic, but the words carried weight. She said she hoped I understood that the association was simply trying to maintain standards that benefited everyone in the community. She said Harold had been difficult in his final years, resistant to change, uncooperative with reasonable requests. She said it would be a shame if I followed the same path. I turned to look at her. She was leaning forward slightly, fingers interlaced on the desk, watching me with an expression that had nothing to do with sympathy. The warning was clear. So was my response. I told her I would see her on Friday and closed the door behind me. Friday came and went without a single document from Diane Hargrove. The receptionist told me the board's legal counsel was still reviewing my request and that I should expect a response within 7 to 10 business days. I thanked her politely and drove straight to the Harris County Clerk's office in downtown Houston. If the HOA was not going to give me the records I needed, I would find them myself. Liens against real property are required to be recorded with the county. And whatever Diane was hiding would show up in the paper trail. The clerk's office was a maze of fluorescent lights and filing cabinets, staffed by people who had seen every kind of property dispute imaginable. I filled out a request form for all recorded documents associated with my uncle's address and waited 40 minutes while a woman with reading glasses and infinite patience searched the system. When she returned, she handed me a thin folder containing exactly 3 documents. The first was the original deed transfer from 1987, when my uncle purchased the property. The second was a satisfaction of mortgage from 2003, showing he had paid off his home loan in full. The third was a lien filed by the Willowbrook Estates Homeowners Association, dated just 6 months ago. Not 3 years, 6 months. And the amount listed was $31,412, not the $47,000 Diane had claimed. A $16,000 discrepancy with no explanation. I asked the clerk if there were any other liens or foreclosure notices on file for this property. She checked twice and confirmed there were none. No notice of default, no lis pendens indicating pending litigation, no record of any communication between the HOA and my uncle regarding unpaid assessments. The first and only action taken against Harold Garcia's property had occurred 6 months ago, 4 months after his cancer diagnosis became terminal, and 2 months before he died. Someone had waited until he was too sick to fight back. Someone had inflated the numbers after the fact, and someone had fabricated a 3-year history that existed nowhere except in Diane Hargrove's manila folder. I drove back to Willowbrook Estates that afternoon, but instead of going to the HOA office, I parked on the street and walked to the house next door to my uncle's property. A man was working in his front yard, trimming hedges with the slow deliberation of someone who had nowhere else to be. He looked up as I approached and squinted against the afternoon sun. I introduced myself as Harold Garcia's nephew and asked if he had a few minutes to talk. His name was Glenn Patterson, 67 years old, a retired engineer, and he had lived next to my uncle for 15 years. He set down his clippers and invited me to sit on his porch. He said he had been wondering when someone from Harold's family would show up. He said there were things I needed to know. Glenn told me that my uncle had been fighting with the HOA for years, not over money, but over the land itself. The 2.8 acres behind his house were the last undeveloped parcel in Willowbrook Estates, and developers had been circling it like vultures since the neighborhood was built. Harold had refused every offer, every pressure tactic, every suggestion that he sell or subdivide. He wanted the land to stay in the family. Glenn explained that he had served on the HOA architectural committee for 8 years before stepping down, and his wife still attended most board meetings as an informal observer. That was how they knew what happened behind closed doors. Diane Hargrove had taken a particular interest in Harold's property about 2 years ago, pushing for new assessments that seemed designed specifically to burden large lot owners. Last year, there had been a closed meeting invitation, only where the board discussed something related to Harold's land. Glenn's wife had overheard Diane talking to another board member in the parking lot afterward. They had been discussing timelines and buyer interest. I asked Glenn if he knew who the potential buyer was. He shook his head but said he had his suspicions. I had noticed the signs myself, driving into the county green and white placards advertising new residential communities, townhouse developments, mixed-use projects. They all bore the same logo, Westbrook Development. Glenn confirmed that Westbrook had been acquiring land throughout Harris County for years. He had seen one of their trucks parked outside the HOA office about 8 months ago, though he did not think much of it at the time. Now the timing seemed less coincidental. I thanked him for the information and asked if he would be willing to put any of this in writing if it came to that. He said he would think about it. He said Harold had been a good neighbor and a good man, and whatever was happening did not sit right with him. Before I left, he told me one more thing. He said I should look carefully at my uncle's will, not just the property transfer, but all of it. Harold had been a careful man, he said, the kind of man who planned for things other people never saw coming. That night, I sat in my hotel room with my uncle's will spread across the bed. I had read it before, or thought I had when the estate attorney first sent me a copy, but I had been grieving then, focused on the big picture: the house, the land, the few personal items Harold had wanted me to have. I had not paid attention to the fine print. Now I read every word, every clause, every footnote. On page 7, in a section titled Special Provisions Regarding Real Property, I found what Glenn had hinted at. The language was precise, almost clinical. The property located at 4127 Willowbrook Lane shall be exempt from any assessment, levy, or financial obligation imposed by any homeowners association, unless such assessment has been approved in writing by the property owner or their designated legal representative. My uncle had built a wall around his land before he died. The HOA had no legal claim to a single dollar, and Diane Hargrove either knew it and proceeded anyway, or had never bothered to check, both of which made her actions indefensible. I called Brittany Flores the next morning from my hotel room. We had worked together at a commercial real estate firm in Austin 8 years ago, before she left to specialize in HOA litigation. At the time, I thought she was making a mistake trading high-value corporate deals for neighborhood disputes. Now I understand why she had made that choice. The cases she handled were about people's homes, their life savings, and their sense of security. And the opponents were often organizations that operated with impunity because no one thought to challenge them. Brittany answered on the third ring and laughed when she heard my voice. She said it had been too long and asked what kind of trouble I had gotten myself into. I told her I needed her expertise. I told her someone was trying to steal my inheritance. She stopped laughing and asked me to start from the beginning. I walked her through everything: the lockout, the meeting with Diane, the county records that contradicted every claim the HOA had made, the exemption clause in my uncle's will. Brittany listened without interrupting, occasionally making small sounds of acknowledgement that told me she was taking notes. When I finished, she was quiet for a moment. Then she asked why I had not handled this myself. I told her the truth. My background was commercial real estate, not HOA disputes, different statutes, different procedures, a different battlefield entirely. I needed someone who lived in this world every day. She said I had come to the right place. Brittany explained that HOA foreclosures in Texas were governed by Chapter 209 of the Property Code. The requirements were strict written notice to the property owner, at least 30 days to cure the default, and either a court order or a properly documented board vote before any foreclosure could proceed. I found myself leaning forward as she spoke, the pieces clicking into place. She asked if I had seen evidence that any of these requirements had been met. I told her the county records showed nothing: no notice of default, no court filings, no documentation of any vote. Just a lien that appeared 6 months ago, with numbers that did not match what Diane had claimed. Brittany made a sound that might have been satisfaction. She said the discrepancy in amounts was significant. If the HOA had inflated the debt after filing, that was a potential violation of the Texas Deceptive Trade Practices Act. I asked about criminal exposure. Brittany paused, and I could hear her choosing her words carefully. She said that if the HOA proceeded with foreclosure knowing the exemption clause existed, we might be looking at attempted theft by deception, but she cautioned that criminal liability required proving intent, and that was always harder than proving procedural violations. She would need to verify the applicable case law before making any definitive statements. Still, she said, at a property value of $1.2 million, the potential charges would be serious if intent could be established. First-degree felony range. I let that sink in for a moment. The stakes had just shifted from a property dispute to something that could end careers and trigger criminal referrals. The next step was clear. I needed the meeting minutes from the board session, where the lien had been authorized. Brittany explained that Texas law required HOAs to maintain accurate records and make them available to members upon request. Diane's claim about confidential documents was legally meaningless. She advised me to submit a formal written request citing Section 209.005 of the Property Code, which mandated production within 10 business days. If they refused, I could file a complaint with the Texas Real Estate Commission and seek a court order compelling disclosure. She also suggested preparing for an emergency injunction to halt any scheduled foreclosure sale. I grabbed a pen and started writing down the statute numbers. It felt good to have a roadmap, even if the terrain ahead was still hostile. I asked how much time I had. She pulled up some information on her computer and told me that standard HOA foreclosure auctions required at least 21 days' notice after the lien was perfected. Based on the filing date, the earliest possible auction would be in roughly 30 days, maybe less if they had already posted notice while I was still trying to get answers. The window was narrow, but not closed. We had enough irregularities to make a strong case for injunctive relief, and the exemption clause was potentially dispositive on its own. If that clause held up, everything the HOA had done collapsed. Brittany said she would draft the formal records request and send it to me by the end of the day. She also offered to make some contacts at the Real Estate Commission and in the Harris County court system who could expedite filings if necessary. I thanked her and asked what she thought our chances were. She paused before answering. She said the facts were on my side, but facts did not always win in HOA disputes. These organizations had resources and a built-in constituency of homeowners who believed whatever the board told them. If Diane were smart, she would try to turn the community against me before I could present my evidence. She would frame me as a troublemaker, an outsider trying to avoid his obligations. I told her Diane had already started down that road. Brittany said that was actually good news. It meant Diane was scared. People who were confident in their position did not need to attack their opponent's character. They just pointed to the evidence. I thought about that for a moment. It made sense. Diane had been defensive from the first meeting, guarding information instead of presenting it openly. That was not how innocent people behaved. Before we hung up, Brittany said one more thing. She said if the meeting minutes showed what I suspected, that the board had acted without proper authorizations, then we were not just fighting to save my property. We were building a case that could reshape how this entire community understood the people running it. She told me to be ready for that. She told me the next few weeks would get ugly before they got better. I looked around the hotel room that had become my temporary home because a stranger had changed the locks on my inheritance. Ugly was where I had been living since this started. At least now, I had the weapons to fight back. The newsletter arrived in mailboxes across Willowbrook Estates on a Tuesday morning. I found out about it from Glenn Patterson, who called me before 9 o'clock with anger vibrating in his voice. He read it to me over the phone while I sat in my hotel room, listening to words designed to destroy my reputation before I could defend myself. The headline was simple and devastating. Protecting our community from financial exploitation. The text beneath it described an unnamed individual who had recently inherited property in the neighborhood and was now attempting to avoid legitimate financial obligations through legal technicalities. This individual, the newsletter claimed, had threatened HOA staff and was spreading false information about the association's leadership. I thought back to my meeting with Diane the moment I had cited property code requirements and told her I would return on Friday. That must have been the threat. Asking questions they could not answer, demanding documents that they did not want to provide. The board urged all residents to disregard any communications from this person and to report any contact to the HOA office immediately. My name was never mentioned. It did not need to be. I drove to Willowbrook Estates that afternoon to gauge the damage. The change was immediate. A woman walking her dog crossed to the other side of the street when she saw me coming. Outside the community center, a middle-aged man in a golf shirt looked me directly in the eyes and said that people who did not pay their debts should not expect a warm welcome. I asked him if he had ever seen the documents supporting those supposed debts. He said the board had explained everything in the newsletter. He said Diane Hargrove had been running this community for years and had never given anyone reason to doubt her. I told him he might want to ask some questions before accepting that at face value. He walked away without responding. One conversation, but it told me everything I needed to know about the ground I was standing on. Glenn met me at his house an hour later. His wife Linda was there too, a sharp-eyed woman in her 60s who had something to show me. After receiving the newsletter, she had gone through her personal files and found the attendance sheet from the board meeting where the lien against my uncle's property had supposedly been authorized. Linda explained that she had served as volunteer secretary for several HOA meetings over the years, because the board's own record-keeping was notoriously disorganized. Minutes went missing, sign-in sheets were never collected, and nobody seemed to care until a dispute arose. So, Linda had started keeping her own copies of everything she handled, a habit born from frustration that was now proving invaluable. The sheet showed 8 signatures. 8 people were present for a vote that required a quorum of 30, 25% of the community's 120 homeowners. The meeting had never achieved the threshold necessary to authorize any action. Every decision made that night, including the lien against my uncle's property, was legally void. I asked Linda if she would be willing to testify about what she had witnessed. She exchanged a look with Glenn, the kind of silent communication that comes from decades of marriage, and then nodded. She said Harold Garcia had been a good man. She said what was happening to his property was wrong. Glenn put his hand on her shoulder and told me there was something else I needed to know, something he had been hesitant to share until now. He told me about a conversation he had overheard 3 months before my uncle died. Glenn had been walking past the HOA office when he heard Diane's voice through an open window. She was on the phone, discussing timelines and property values with someone whose name Glenn did not catch. But he remembered one phrase clearly: "Once the old man is gone, the family will sell. They always do." At the time, Glenn had dismissed it as speculation. Now he believed Diane had been planning this for months, positioning herself to profit from my uncle's death before the body was cold. I asked Glenn if he knew who Diane had been speaking with. He said he had done some research after our last conversation. Westbrook Development's regional office had a land acquisition director, Raymond Cross, who had been working on projects in the Willowbrook area. Glenn could not prove that Diane had been speaking with Cross that day, but the circumstantial evidence was mounting. Diane had a relationship with a developer who wanted land in this neighborhood. My uncle owned the largest undeveloped parcel, and the moment he became too sick to fight, the HOA had begun fabricating grounds to seize his property. That evening, I began collecting signatures for a special meeting. The HOA bylaws allowed any group of homeowners representing at least 20% of the community to demand a general assembly within 14 days. I needed 24 signatures. Glenn and Linda provided the first 2. Over the next 3 days, I knocked on doors, explained what I had discovered, and asked people to consider whether they trusted the current leadership. Most residents refused to speak with me, but a handful listened. They asked questions, they looked at the attendance sheet and the county records I had brought with me, and slowly, reluctantly, they signed. By Friday afternoon, I had 27 names, 3 more than the minimum required. I delivered the petition to the HOA office that same afternoon. The receptionist took the document without meeting my eyes. She said she would forward it to Mrs. Hargrove for review. I told her that a review was not required. The bylaws mandated a meeting within 14 days of a valid petition, and I had just delivered one. She said Mrs. Hargrove would be in touch. I told her I would be waiting. I turned to leave, and that was when I saw at a bulletin board by the entrance that I had walked past without noticing on my way in. In the center was a new flyer, printed on bright yellow paper. Emergency board meeting members only Friday evening. The date was 3 days from now. The meeting I had just petitioned for was not listed anywhere, but Diane was already planning her own gathering. one where she could consolidate support before I had a chance to present my evidence publicly. She was moving faster than I had anticipated. The war for Willowbrook Estates was about to begin in earnest, and I needed to be ready for whatever she was planning behind those closed doors. The special meeting was scheduled for Saturday afternoon at 2 o'clock in the Willowbrook Estates Community Center. I arrived 30 minutes early and found the parking lot already filling with cars. Word had spread not just about the petition, but about the evidence I claimed to possess. Some residents came out of curiosity, others came to defend Diane. A few, I suspected, came hoping to watch a fight. By the time the meeting was called to order, more than 80 people had packed into a space designed for 60. This was the largest HOA gathering in the community's history, and everyone knew something significant was about to happen. Diane Hargrove sat at a table on the platform with two other board members, Carol Gonzalez, and a man I did not recognize. She was dressed impeccably, her silver hair swept back, her expression a mask of calm authority. When she called the meeting to order, her voice carried the practiced confidence of someone who had run hundreds of these gatherings. She began by thanking everyone for their attendance and acknowledging that there had been some confusion in the community recently. She said the board had received a petition requesting this meeting, and while the circumstances were unusual, she believed in transparency and open dialogue. Then she turned her attention to me. She said that before any discussion could proceed, she wanted to address the source of the recent disruption. She invited me to stand and introduce myself to the community I was apparently so eager to join. I stood slowly, aware of every eye in the room tracking my movement. I had prepared for this moment for days, running through scenarios, anticipating objections, organizing my evidence into a sequence that would be impossible to dismiss. But standing there, facing a room full of strangers who had already been told I was a liar and a deadbeat, I felt the weight of what I was about to do. This was not a courtroom. There was no judge to ensure fair play. It was just me against a narrative that had been building for weeks. I took a breath and began. I said my name was Ethan Mercer, nephew and sole heir of Harold Garcia, who had lived in this community for 37 years. I said I had come to claim my inheritance 6 weeks ago, and instead discovered something that every person in this room needed to understand. Then I added one detail I had kept private until now. My professional background was real estate law, and I had spent 3 weeks investigating whether this board had followed the legal requirements for its actions. The murmuring started immediately, people turning to neighbors, whispering, reassessing. Diane interrupted. She said this was not a forum for personal grievances, and that if I had legal concerns, I should address them through proper channels. I told her I had tried proper channels and been stonewalled. Then I said something that changed the temperature in the room. I said what I had found suggested that the board had committed fraud. I laid out the evidence piece by piece. First, the lien. I explained that the Texas Property Code required written notice before any lien could be filed, with at least 30 days to cure the alleged default. I held up the county records showing that the lien against my uncle's property had appeared 6 months ago, with no prior notice on file. Second, the amount. I showed the discrepancy between the $31,000 recorded in the county filing and the $47,000 Diane had claimed. A $16,000 difference with no explanation. Third, the meeting. I held up the attendance sheet that Linda Patterson had preserved 8 signatures for a vote that required 30 people to achieve a quorum. The lien had been authorized by a gathering that lacked the legal authority to authorize anything. Diane leaned forward and cut in before I could continue. She said that the document was a preliminary sign-in sheet, not the finalized attendance record. She said additional members had arrived after the sheet was circulated, and that the official minutes reflected the actual count. I asked her to produce those official minutes. She said they were in the board's files and had not been brought to this meeting. I asked why not, given that she knew attendance records would be relevant to any discussion of procedural compliance. She did not answer. A woman in the third row raised her hand and said she had been at that meeting. She said no one had told her it was a vote to foreclose on anyone's property. She said Diane had described it as a routine administrative session to review outstanding accounts. She said she had no idea that standard collection procedures meant filing liens and initiating foreclosure. Another voice rose from the back, a man asking why the amounts did not match. Someone else demanded to know why proper notice had not been sent. The controlled environment Diane had maintained for years was beginning to fracture. Diane stood and raised her hands, calling for order. She said these were complex financial matters that could not be adjudicated in a community meeting. She said the board had followed all proper procedures and that any discrepancies I claimed to have found were the result of my own misunderstanding. She said I was an outsider who had been here for less than 2 months and had no standing to question decisions made by people who had dedicated years to serving their neighbors. Her voice remained steady, but I noticed her left hand had moved to grip the edge of the table knuckles, whitening against the wood. I waited until she finished, then I delivered the final piece of evidence. I explained that my uncle's will contained a special provision, a clause stating that his property was exempt from any assessment or levy imposed by the homeowners association, unless approved in writing by the property owner. I held up a copy of the relevant page, the language highlighted in yellow. Harold Garcia had anticipated exactly this kind of overreach, and he had built a legal fortress around his land before he died. The HOA's entire case rested on assessments that my uncle had never agreed to pay and was legally protected from owing. Every notice, every lien, every foreclosure action was built on a foundation that did not exist. Diane took a small step backward, her hand releasing the table to find the back of her chair. For the first time since I had arrived in Willowbrook Estates, she had no prepared response. That was when Glenn Patterson stood up. He had been sitting quietly through the entire presentation, positioned near the middle of the room where he could observe both the platform and the audience. I had noticed him tracking Diane's reactions, waiting. Now he rose, and the people around him shifted to give him space. His voice was calm but carried clearly to every corner of the community center. He said he had a question for Mrs. Hargrove. He said he had lived in this neighborhood for 15 years and had always trusted the board to act in the community's interest. But recently, he had learned some things that troubled him deeply. He paused, letting the silence build. Then he asked Diane directly, why had she been in contact with Westbrook Development about Harold Garcia's property before Harold even died? The room erupted. People turned to look at Diane, then at Glenn, then back at Diane. Someone shouted for an explanation. Someone else demanded to know what Westbrook Development had to do with any of this. Diane's mouth opened, closed, then opened again. Her hand found the table once more, but this time it seemed less like control and more like the need for something solid to hold on to. A flush crept up her neck toward her jawline. For 5 seconds that felt like an hour. The president of the Willowbrook Estates Homeowners Association stood frozen at the front of the room, facing a question she could not answer without destroying everything she had built. The silence after Glenn's question lasted only a moment before voices began rising throughout the room. People were turning to their neighbors, asking what Westbrook Development was, demanding to know what Glenn meant. Diane stood at the front like someone who had just been struck not falling, but no longer steady. I watched her search for an escape, her eyes moving to the side door, to the other board members, to anywhere that might offer a way out. But there was nowhere to go. The community she had controlled for years was now staring at her, waiting for an explanation she could not provide without incriminating herself. Then something unexpected happened. Carol Gonzalez, the board member sitting to Diane's right, pushed back her chair and stood up. Carol was a small woman in her 50s, soft-spoken by reputation, someone who had served on the board for 3 years without ever making waves. Now she looked at Diane with an expression I could only describe as disgust. She said she had something to say. She said she had been carrying it for months and could not stay silent any longer. She said that when the board had discussed the lien against Harold Garcia's property, she had raised concerns about the process. She had asked whether proper notice had been sent, whether the amounts were accurate, and whether they had the legal authority to proceed. Diane had dismissed every question. Diane had told her it was a routine administrative action and that the board's legal counsel had approved everything. Carol said she had trusted that assurance. She said she had voted yes because she believed her president was telling the truth. Now she understood that she had been used to provide cover for something much darker. Carol turned to face the audience. She said she was resigning from the board effective immediately. She said she could not be part of an organization that operated this way. Then she walked down from the platform and took an empty seat in the second row, leaving Diane standing with only one remaining board member, a man who looked like he wanted to disappear into the floor. Diane attempted to regain control. She straightened her blazer, lifted her chin, and said that Carol's statement was emotional but not factual. She said the board had acted properly and that these accusations would be addressed through appropriate channels, but her voice had lost its earlier authority. The words came out thin, rehearsed, unconvincing. Before anyone could respond, a man near the back of the room stood up. I did not recognize him at first, middle-aged, wearing a rumpled button-down shirt, holding a manila folder against his chest. He introduced himself as Charles Mendoza. He said he had been the HOA's contracted accountant for the past 4 years. He said he had prepared the financial documents that supported the lien against the Garcia property. And then he paused. His hands were trembling slightly against the folder. He said he knew that what he was about to say might expose him to legal consequences, but he could not live with it anymore. He said those documents were fraudulent. The word landed hard. Charles continued, his voice unsteady but determined. He said Diane had contacted him 2 weeks after Harold Garcia's death and asked him to prepare an invoice showing $47,000 in unpaid assessments. He said he had questioned the amount because it did not match any records in the HOA's books. The actual outstanding balance, according to his files, was 0. Harold Garcia had paid every assessment on time for 37 years. Diane had told Charles to create the invoice anyway. She had called it a technical correction for fees that had been miscategorized. Charles opened his manila folder and held up a sheet of paper. He said this was the original invoice he had created at Diane's request, with her handwritten notes in the margin. He said he had kept a copy because something about the situation had felt wrong from the beginning. A woman in the 4th row interrupted. She said this was a lot to take in and asked how they could be sure Charles was telling the truth. Maybe he had his own reasons for making accusations. The question created a ripple of murmuring, some people nodding, others looking uncertain. It was a fair point, and for a moment, the room's momentum shifted. Charles looked uncomfortable, but he responded. He said he had nothing to gain by coming forward and everything to lose. He said he was prepared to provide his documents to law enforcement and to testify under oath. He said anyone who doubted him could verify the records themselves. The woman sat back, not entirely satisfied, but unable to argue further. I let the moment settle before raising my hand and asking for attention. I said there was one more piece of evidence that might help clarify things. I reached into my briefcase and pulled out a stack of printed emails. Brittany had obtained them through a discovery request filed with the court 3 days earlier. After we secured an emergency injunction, halting the foreclosure sale, the emails were correspondence between Diane Hargrove and Raymond Cross, the land acquisition director at Westbrook Development. They dated back 18 months. I read selected passages aloud. In one email, Diane mentioned that the Garcia property might become available depending on certain circumstances. In another, she discussed the possibility of expediting matters if the situation changed. In a third, dated just 2 weeks after my uncle's funeral, she wrote that progress was being made and suggested they meet to discuss next steps. The language was careful, no explicit admissions, but the pattern was unmistakable. Then I read the final email, the one that removed any ambiguity. It referenced a consulting arrangement and a payment of $200,000 upon successful completion of the project. The room did not erupt this time. It went cold. I watched faces transform as people absorbed what they were hearing, not just procedural violations, not just inflated numbers, but a coordinated scheme to profit from a dying man's property. $200,000. That was what Diane had valued my uncle's life's work at. I set the emails down and looked at Diane. She had stopped trying to maintain her composure. Her shoulders had dropped, her hands hung at her sides, and she was staring at the table in front of her, as if the wood grain held some answer she could not find anywhere else. The remaining board member stood up and announced that he was resigning, effective immediately. He said he had not known the extent of what was happening. He left the platform and walked out of the building without looking back. Someone in the crowd called for a vote of no confidence. The motion was seconded immediately. A man near the front, someone I had noticed nodding along with Diane's earlier defense, raised his hand and asked if they were really going to remove a president based on accusations that had not been proven in court. Another resident responded that the evidence was clear enough and that waiting for courts meant waiting for years. The exchange lasted less than a minute before someone called for the vote to proceed. I reminded everyone that under the bylaws, such a vote required a simple majority of members present. The count was taken by a show of hands. 67 in favor, 3 opposed, 12 abstentions. Diane Hargrove was removed as president of the Willowbrook Estates Homeowners Association. She did not speak as she gathered her things from the table. She did not look at anyone as she walked down from the platform and through the center aisle toward the exit. The crowd parted for her in silence. At the door, she paused for just a moment, her hand resting on the frame. I thought she might say something, but she just stood there, her back to the room, her head slightly bowed. Then she pushed through the door and was gone. I turned to face the community that remained. I told them this was not about me. I told them that what had happened to my uncle's property could have happened to any of them. I told them the systems that were supposed to protect homeowners had been corrupted, and now they had a chance to rebuild those systems the right way. I told them I would be filing a formal complaint with the Texas Real Estate Commission and pursuing criminal fraud charges and attempted theft. And I told them that Harold Garcia had spent 37 years in this community because he believed it was a place worth protecting. I intended to honor that belief. The room was quiet when I finished. Then Glenn Patterson started clapping. Within seconds, the applause had spread not triumphant, but resolute. The battle for Willowbrook Estates was over. The work of rebuilding was about to begin. The criminal charges came 3 weeks later. The Harris County District Attorney's Office filed a formal indictment against Diane Hargrove on counts of fraud, attempted theft by deception, and filing false documents with a government agency. The property value involved $1.2 million, elevated the theft charge to first-degree felony territory, carrying a potential sentence of 5 to 99 years. Raymond Cross and Westbrook Development were named as co-conspirators in a civil suit filed separately by the new HOA board. Charles Mendoza received immunity in exchange for his testimony and cooperation with investigators. The forensic audit he helped facilitate uncovered additional irregularities in the association's finances, smaller amounts, other properties, a pattern of manipulation that stretched back at least 4 years. Diane had not just targeted my uncle. She had been running a quiet operation that enriched herself at the expense of the community she claimed to serve. The HOA held its first legitimate board election in early December. Glenn Patterson was elected president by a margin that surprised no one. Linda became secretary, bringing her meticulous record-keeping habits to an organization that desperately needed them. The new board's first official action was to void every lien and assessment that had been approved without proper quorum, including, of course, the one against my uncle's property. The foreclosure was formally dismissed, and I received a letter of apology signed by all 5 new board members. It was a small gesture, but it mattered. Someone in this community had finally acknowledged that what happened to Harold Garcia was wrong. I moved into my uncle's house on a cold Saturday in January. The locksmith who had changed the locks back in October was the same one who installed my new deadbolt, a detail that felt almost poetic. The house needed work. 3 months of neglect had taken a toll, and the garden my uncle had maintained so carefully was overgrown and wild. But the bones were solid, the land was beautiful, and every room held memories that I was only beginning to rediscover. I found photographs I had never seen, letters from relatives I had never met, a lifetime of careful documentation that told me exactly who Harold Garcia had been. He was a man who believed in doing things right. He was a man who planned for contingencies others never imagined. And he was a man who trusted me to protect what he had built. Brittany called to congratulate me when the dismissal became official. She said cases like this were why she had left corporate law, the chance to help people fight back against systems designed to crush them. I thanked her and promised to send referrals her way. Then I walked out onto the back porch and looked at the 2.8 acres stretching toward the tree line. Somewhere in the distance, I could hear children playing. Glenn Patterson waved from his yard next door. I waved back. My uncle had spent 37 years in this community because he believed it was worth protecting, standing on his land, in his house, surrounded by neighbors who had finally found the courage to demand accountability. I understood why. Some things are worth fighting for. This was one of them.